Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are just a couple of weeks away from the start of the 2023 legislative session. And yes, we in the lawful and responsible gun owning community know that we are in for one hell of a Donnybrook come this legislative session. One of the big pieces of legislation that your governor and attorney general were proud to announce is, yes, they will once again be trying a semi-automatic rifle ban, or what they like to call an assault weapon ban. Has many of us completely freaking out. What happens if this is the year that it finally happens? Would it stand constitutional muster in the long run? Probably not. But would it subject us to a lot of pain and misery in the meantime? It most certainly would. So today we're going to spend a few minutes and talk about what a Washington State semi-automatic rifle ban might look like. Okay, before we get going down the road we're going down, proud to announce that this video is being brought to you by Federal Way Discount Guns. That's right, one of Washington's premier FFLs is located right here in Federal Way, Washington. Now, in addition to having an amazing retail operation, an amazing staff, and a fantastic indoor shooting facility, as many of you know, Federal Way Discount Guns has drawn the attention of your Attorney General. So if you are interested in helping out the good folks at Federal Way Discount Guns, go ahead and visit the link in the description box down below, or go ahead and scan this QR code right here, because if you want to contribute to their legal defense fund, you will have the ability to do so. Listen, people like Federal Way Discount Guns, Gimme Guns over in Selah, Washington, and a lot of other folks have stuck their neck out to fight for your Second Amendment rights, and it's time that we all show them some love. For more information, visit my good friends at federalwaydiscountguns.com. Okay, so the issue we're talking about today is one of those great what ifs. What if a semi-automatic rifle ban was actually passed by your Washington State legislature? What might it look like? Now, for those of you who've heard some of the interviews I've done with Victoria Taft on KTTH and stuff like that, you know that I have occasionally been critical of our governor because I don't believe he comes up with particularly original ideas. I think he basically is a copycat governor. He looks at whatever Governor Newsom does with goo-goo eyes and tries to emulate it. Well, when it comes to what kind of a semi-automatic rifle ban might we see in Olympia this legislative session, I think we have to look no further than the last 6 versions of a semi-automatic rifle ban that's been proposed in the Washington State legislature. Most recently, last year, Senate Bill 5217. Now, despite the fact that we covered a lot of aspects of last year's legislative session, 5217 didn't get a lot of attention because once it went into committee, it kind of just died on the vine there. It never really got out of committee. It never really picked up steam like 5078, the magazine ban, 1705, the untraceable firearm issues, and 1630, new bans on where we can and cannot carry firearms. Those all garnered a lot of momentum and ultimately were passed and signed into law. 5217 kind of remains stagnant. However, do I believe that 5217 is going to renew its ugly head again this year? It most certainly is. It will be assigned a new bill number, and there will be a companion bill over in the House that will be assigned a new number. But do I believe that the language in this proposed legislation is going to change significantly from what we've seen in the past? No, I don't. For that reason, let's dive into Senate Bill 5217 and see what this horrible, crappy piece of legislation would have done to you, the lawful and responsible gun owner. Okay, so right off the bat, and we're seeing this all around the country, is what these states are doing that are attempting these semi-automatic rifle bans is essentially they are creating a new definition called assault weapon. Now, I know that some of you are freaking out because I use that dreaded term, but understand that I am using the terminology that is in the statute. My job is to educate you about what the law means, so I have a tendency to use the actual terms that are in the law. So what these state legislatures are doing is after they create the new definition of assault weapon, they then encapsulate just about every conceivable type of firearm that one would think would fall under that category, not only by just naming them by names, but also listing a whole bunch of components that are very common to these platformed firearms. 5217 specifically stated, a new section is added to Chapter 9.41 RCW to read as follows. Assault weapon means any of the following specific firearms or a copycat weapon, regardless of which company produced and manufactured the firearm. So then they go on to list a whole litany of firearms, which we'll get to in just a second. But to give you an idea, they're not only talking about actual firearms, they're also talking about copycat firearms, firearms that are meant to mimic semi-automatic rifles, or what the state now wants to call assault weapons. But just to give you an idea of how generalized some of the firearms that are being included in this prohibited category, 5217 specifically stated that the following firearms would be banned: AK-47 in all forms, AK-74 in all forms, AR-15, M16, or M4 in all forms. And then in addition to that, as I stall and stall and stall here so we can put all of these graphics up for you to see, you can see that Senate Bill 5217 had a litany, and I do mean a long, long list of firearms specific to make, model, and so forth that would have also been banned by this legislation. But wait, there's more, because in addition to the outright banning of those particular firearms, 5217 encapsulated much more, because the bill also stated that the following firearms would now be deemed unlawful: B, a semi-automatic centerfire or rimfire rifle that has an overall length of less than 30 inches, or C, a conversion kit, part or combination of parts from which an assault weapon can be assembled if those parts are in the possession or under the control of the same person. Which arguably means that if you have a lower receiver and an upper receiver and you possess both of them sometime after the enactment of law, that too is in violation of the law. But wait, there's even more, because they talk about copycat weapons. Now, what the hell is a copycat weapon? Well, a copycat weapon is a catch-all phrase that the Washington State Legislature came up with to basically include any other conceivable firearm that has any type of configuration or components to it that we commonly associate with the AR and AK platforms. In fact, the bill specifically read, a copycat weapon means a semi-automatic centerfire firearm that has the capacity to accept a detachable magazine and has one or more of the following. And so one or more of the following makes this copycat weapon just as dangerous and just as illegal as an assault weapon. And they include A, a pistol grip; B, a thumbhole stock; C, a folding or telescoping stock; D, a forward pistol, vertical, angled, or other type of foregrip; E, flash suppressors; F, muzzle brakes or recoil compensators; G, threaded barrels designed to attach flash suppressors. So you can see that if this legislature is claiming that they are only trying to remove weapons of war from the streets, no. This bill, if it is again revived in this format, prohibits much more than what these legislators are claiming to prohibit. Now, the next question, of course, is, well, I own several of these firearms, so am I going to be grandfathered in? Now, that question was asked during this press conference. Well, I wouldn't really call it a press conference, more than like a media circus, but that was asked of Representative Kathy Curterer out of Bellevue, who is absolutely leading the charge on all of these anti-Second Amendment bills, okay? And she specifically stated that there was a grandfather provision that would be added to this bill. 5217 also had a grandfather provision, and I want you to be aware of this, because if this is similar to what we're seeing in this legislative session, there may be some preparation for all of us to take, because the bill specifically stated, no person in this state may manufacture, possess, distribute, import, transfer, sell, offer for sale, purchase, or otherwise transfer any assault weapon except as authorized in this section. And then the law specifically excluded several activities, most of which are related to military and law enforcement, so I'm not going to bore us with that detail on this video here. But for you, the average citizen, the exception was as follows. The possession of an assault weapon by a person who legally possessed the assault weapon on the effective date of this section, or possession of an assault weapon by a person who, on or after the effective date of this section, acquires possession of the assault weapon by operation of law upon the death of the former owner who was in legal possession of the assault weapon, provided the person in possession of the assault weapon can establish such provenance. What the hell is provenance? Provenance is a fancy word for show me that you're the legal owner. Show me that you came into lawful possession of this firearm. So for any of you who could be inheriting firearms because of the death of a loved one, yes, you need to make sure that all the estate planning documents necessary to show the transfer of those firearms are in order. Now, the statute also went on to further explain that this exception included a person who legally possesses an assault weapon under this subsection may not sell or transfer the assault weapon to any other person in this state other than to a licensed dealer, to a federally licensed gunsmith for the purpose of service or repair, or to a law enforcement agency for the purpose of permanently relinquishing the assault weapon. And so now we are beginning to get into what's called the unconstitutional takings area, okay? Because what they're saying is, hey, listen, if you possess one of these, that's great up until the day you die. Because once you die, there is no other legal way by which you can transfer this firearm to another person. Now, I know some of you are sitting there going, well, what about a gun trust? We will do some videos about that as we get closer and we begin to see what this implementation may look like if it's in fact going to pass. But here's the thing you need to know about gun trust in Washington State, and that is that if we have NFA items, Title II, federally regulated, ATF regulated firearms, we can transfer those into gun trust because transferring to an entity is possible. However, if we're talking about non-Title II firearms, handguns, shotguns, rifles, and semi-automatic rifles, no, the ability to actually transfer ownership of that firearm to an entity such as a trust is not legally possible due to the paperwork that the feds in Washington State have put together. Now, in addition to this kind of weird grandfathering clause, 5217 would have also limited where we can use our grandfathered semi-automatic rifles as follows. In order to continue to possess an assault weapon that was legally possessed on the effective date of this section, the person possessing the assault weapon shall possess the assault weapon only on the property owned or immediately controlled by the person, or while engaged in the legal use of the assault weapon at a duly licensed firing range, or while engaged in lawful outdoor recreational activities such as hunting, or while traveling to or from either of these locations for the purpose of engaging in the legal use of the assault weapon, provided that the assault weapon is stored unloaded and in a separate locked container during transport. Now that last part completely throws me off. As we know under RCW 77.15.460, we cannot carry shotguns or rifles loaded in the automobile under any circumstance if the vehicle is underway. Why suddenly we would need to lock our semi-automatic rifles in a case is beyond me, but that's what this legislation stated. More troubling is that if we are allowed to grandfather these firearms in, this legislation would basically limit the use of the firearms to inside our home and at a range, which also means that the open carrying of these firearms, which I recognize is a constitutionally protected activity that many of you actually like to engage in, would become prohibited by this if it was enacted into law. And then the final coup de grace is a violation of any portion of this section under the proposed Senate Bill 5217 would have constituted a Class C felony, which means it's punishable by up to 5 years in prison, up to a $10,000 fine, but would also, any conviction would immediately disqualify that person from possessing firearms in any way, shape, or form, or possessing a concealed pistol license. Now, am I saying that what's going to get dropped on us this legislative session is going to be exactly the same as what we've seen? Perhaps, perhaps not. It will be in a very similar format, and I would consider that a large majority of what was in 5217 will be in this new bill as well. Now, listen, we will keep you posted throughout the entire legislative session like we did just last year. In the meantime, if you have any questions about this or anything else related to your Second Amendment rights, you guys know the drill. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.